as one of your reasons for a request that it's a hardship, basically, it's a health hardship? Is that the way? Okay. Could be?
It was last year when he was paralyzed for all winter long. We hope it won't happen again, but.
Is there anybody here that would like to speak for the grant of the area variance? How about against? All right. One thing that I will add to the minutes is that I know that you've consulted your next door neighbor on the side that the bathroom would actually go on, and she has said that she has no objections to the Rowleys adding an addition to their home. Okay, so we can add that to the minutes. Okay. Are there any other questions from the board?
What's to your line? How many feet you got there now?
19 feet.
So you only want 5 foot.
Actually, it's 18.1 from the front corner. Actually, I think this is north. This is where they want to have it. Here? Yeah, in fact, here are the pictures that I...
So they only want a 5-foot variance then, right?
7-foot variance.
7 foot?
Hasn't changed since we saw it, has it?
Not at this time.
Did you look into any other method, whether it could be achieved by any other, is there any other feasible method?
No way.
No way on the back of the house?
No, there isn't. There's a septic out in the back. It was closed off our kitchen.
Once it's constructed, what will the outside look like?
Just like the house.
Just like this, so it's gonna fit right in.
The same siding and roof and everything.
Any other questions? I guess I could entertain a motion if there's no further discussion.
I'll so move
Okay, do you want to,
that
second?
Mr. Rowley gets the variance.
Okay, can you give us some reasons, Dan? We have to give specific reasons.
There are people that are getting older and have to go upstairs, and they need a downstairs bathroom.
Okay. Have you seconded that? Yeah.
We got more.
Yeah, I think we need to ask a little bit more.
I don't think that the variance is substantial. I don't think it will change the character of the neighborhood, and we have the approval of our neighbor.
I'd also like to add that, in terms of another feasible method, it would not be feasible to put it in the back of the house because, as Mrs. Rowley has stated, their septic system is there. So this seems to be the only feasible method to add another bathroom.
I agree. It's also not self-created. I don't feel we have any adverse effect on the neighborhood.
Chairman Conway,
Yes?
Sam Kukurudo,
Yeah.
Jim Hinman,
Yes.
Deborah Sprague,
Yes.
Dave Winfield.
Yes.
Okay, you have your variance, and I will notify you in writing within 10 days, okay, so you can get started. Okay? Thank you. Okay, let's get the second public hearing underway. And I just would like to read a statement first to kind of clarify what it is we're going to try and do here tonight. The second public hearing is a request made by the Town of Volney Planning Board for an interpretation of the zoning ordinance as it relates to commercial parking. More specifically, the Planning Board is appealing the initial determination by the Codes Enforcement Officer that the parking of fully loaded trailers for several days at a particular location would constitute commercial parking. It is their belief that this would be a form of warehousing. Number two, their concern revolves around the belief that commercial parking must be directly related to or have direct business with a structure or commercial business that is adjacent to or on the same parcel as. A little bit about the chronology of events. All of this came about when Earl Longley of Longley Brothers Incorporated approached our Codes Enforcement Officer, Dan Russo, with a proposed plan to lease property at the rear of his car dealership to a trucking company to park tractor trailers only. There is no truck terminal involved that I'm aware of, as was the case in a prior application. I believe it was in 1984. Our Codes Enforcement Officer feels that this new request is for a commercial parking lot and is not a warehouse situation. Since he feels that it's for a commercial parking lot, it would only require site plan approval and an issuance of a special use permit by the Zoning Board of Appeals. I just would like to read a little bit of what Dan wrote to us. In regards to the Town of Volney Planning Board's letter, I would like to list and address my reasons for feeling that this request is for a commercial parking lot and not a warehouse situation. Number one, on pages Z06 and 15 of our zoning laws, you should note that a commercial parking lot is listed as a specific use. Number two, trailers would not be left on site for several days for the following reasons. A, Miller policy is that a trailer load of beer will be at its final point of destination within 4 days. 9 times out of 10, this final point of destination is in another state, necessitating trailer loads of beer be on the road within hours of leaving the Miller plant. B, beer freezes at a temperature just below 32 degrees Fahrenheit. This would prohibit a trailer load of beer from sitting around on the lot as it must be moved to the warehouse before it freezes. C, the same applies during the summer months in regards to heat, as the closed-up trailer heats up quickly, causing the beer to spoil, thus necessitating rapid removal to the warehouse. Number 3, definition of a warehouse according to Webster's Dictionary, a building where goods are stored. Definition of warehousing, the storage of goods in a warehouse. Number 5, tractors and their trailers are legally registered motor vehicles with any state's Department of Motor Vehicles. As such, this would make them a vehicle and not a warehouse, as they are not a building. Buildings cannot be registered with the Department of Motor Vehicles. Number 6, while a judge in the last case raised the question of possible warehousing, it should be noted that the judge made no attempt to investigate this line of reasoning. Number 7, many of the trailers coming into this lot will be empty trailers, as many of the trailers, when leaving the plant, will proceed directly to their final destination point. Number 8, the trailers in question pay thousands of dollars per year in road taxes. Number 9, a parking lot is an area of land or building used to park motor vehicles. The charge of a fee for its use would thus make this a commercial parking lot. Number 10, there are no buildings proposed at this time, only an area of land to be used for parking trailers. In regards to item 2 on the Planning Board's letter, I would offer the following. Number 1, on page Z06, a commercial parking lot is listed as a separate use. Number 2, on page Z015, a commercial parking lot is addressed as a separate item. Number 3, as on page Z015, I cannot see where a commercial parking lot is mandated to be tied in with a business. Number 4, as a commercial parking lot is addressed at least 2 times as a separate item, it leads me to believe that a commercial parking lot was meant to be a separate item of its own. Number 5, on page Z06, a commercial parking lot is listed as being allowed with site plan approval and with a special use permit from the zoning board. Number 6, if a commercial parking lot were to be allowed only when being tied in with a business, it would not be listed in a title of its own, as it could be tied in through an accessory use section. Due to the fact that it is addressed at least 2 times in its own name, this leads me to believe that it was meant to be a separate use of its own. Number 7, nowhere in our zoning does it state in any way, shape, or form that a commercial parking lot must be tied to an existing business. Dan turned the situation over to the planning board for site plan review, and while Mr. Longley presented them with a site plan, there's been no application made to the zoning board of appeals for a special use permit. Therefore, we are not making a decision tonight on whether Mr. Longley does or does not get his tractor-trailer parking lot. Rather, we've been asked to interpret what our ordinance means by commercial parking. Are the words clear? Could I comply with the regulations for commercial parking lots in a business convenience zone without having a building adjacent to the lot? If the statute is confusing or not clear, then we, the ZBA, have the right to look beyond the words at intent, minutes from past cases, letters from the public, testimony from those that passed the zone change in 1985, testimony from those that were there, and any other extemporaneous information. We will hear public comment, but only as it relates to the determination that we're trying to make about commercial parking and warehousing. Time limit on individual comment is going to be limited to 5 minutes. And so at this point, what I'd like to do is ask Dan if he has any additional comments, the letter that he addressed to us and to the planning board.
No, I think I covered it pretty well. I just sat down and looked at it item by item, and that's, you know, basically what I came up with. There are several alternatives, but the big issue that stands out the most is the fact that commercial parking is specified in the front of the zoning as being allowed with a special use permit and site plan approval. That to me indicated that a commercial parking lot could be an item of its own. And when I talked with Mr. Chatfield, he pretty much agreed that because it's listed separately, he more or less read it the same way.
Kevin, do you have any comments on behalf of the planning board?
No, I think the planning board, requested that you interpret this, and not at this time, no.
Okay. Okay, then what we'll do right now is take public comment. So what I'd like you to do, and I'll read your names in the order that they are on the list.
Madam Chairman?
Yes.
My name is Andrew Fluxo. I'm an attorney from Auburn who's been hired by the residents in this matter, and I would like the opportunity to address the board and circulate some materials that I brought with me tonight. I didn't sign the sign-in sheet because I didn't know the rules here,
Okay.
but I would like to be given the opportunity to speak at whatever time you deem prudent.
Okay, why don't you go ahead and start?
Okay, thank you. Might I pull this table over here to be able to work off of it?
Mr. Chairman?
Yes.
Shouldn't he sign in, just like everybody else, and can speak at the appropriate time on the list?
If
I didn't hear you announce in the beginning of the meeting that you're gonna sign in,
Well, I announced it as people were coming in to sign in on the sheet.
as they were coming in.
As they were coming in. I will formally make an announcement.
Bring it back around.
Pardon me?
Could you bring
Yes,
this
I
back
certainly
around?
will, I'll pass this back around.
Might not get it.
Sure.
Too far out of reach.
Is anybody here, I guess, against the attorney opening? Because if you are, then we'll do it as in order. Okay, go ahead.
Okay, first of all, what I'd like to do, ladies and gentlemen of the board, is circulate these packets of information, and if we can keep them in order, go through them.
I don't think the night will be long enough.
I don't think so either. Be here about 3 weeks.
And I do beg your indulgence in this matter. As you know, this is a case that's gone on for some time, and by my own calculation, this is the 4th or 5th time, I should say, that this particular request for a truck terminal or a truck parking lot of some type at this location has been brought before a municipal board in the town of Volney. On 4 occasions, Mr. Longley has been told no, yet here we are a 5th time again tonight going over something that I thought had been decided 7 years ago. This packet is in order. Each one of the documents is denominated with a little letter on the bottom in pink, A through Q, and I'll start with A. A is the application which Mr. Longley submitted to the Town of Volney Planning Board regarding his proposed use off of Crescent Road. I've highlighted 2 things on it. Number 1, applicant's intention to lease 4 acres for a truck trailer parking and transiency station. I don't know what the word transiency means, and I don't quite know what that spelling of that word is there. I don't think that
Looks
is.
like transfer,
Transfer, okay.
like a transfer station.
Okay, but it seems to end in the letter CY, so I don't quite know what it means. And then it adds no loading or unloading. I also know from the application that the applicant is required to list at least 2 neighbors so that the notice provisions in the law of the state of New York can be met. Mr. Longley submitted no neighbors' names, so to clarify that obvious overlooking of the application, I'd like to submit to you 79 names of what neighbors in the area that have signed a petition opposed to this particular use.
Can I have a point of order here?
Sure.
I don't think this is relevant for what we're doing here tonight.
Okay, well,
We're strictly discussing the definition of,
yeah.
commercial parking, and arguing, whether or not this is allowed.
Dan's correct. Basically, what we're doing here tonight is just interpreting the ordinance. This is basically extemporaneous information at this point.
Right, and all it is by way of...
And we're trying to limit the time as well.
Right, just by way of introduction, all I'd like to do is to allow you to know that my clients are opposed to this particular use. As you had said in your remarks at the outset, the public's input and what went into the intention of this is all relevant, and I'd have to suggest that the petition in opposition to the terminal and your interpretation is something to be considered. Okay, now moving to document number B, the next in the list. You've read a letter into the record from Mr. Rousseau regarding why he feels that this is a legitimate use in a B zone. This property had been rezoned in September 1985 to business use. The January 14th, 1992 Planning Board meeting minutes are before you on number B. And I just want to read to you, and I've highlighted one of the things that Mr. Rousseau told the Planning Board that particular night. He told them that he thought that this particular use was allowable because it was being leased, not sold. I note that he didn't say anything about that in his letter to you that you just read into the record. And I have to submit to you, ladies and gentlemen of the board, that there's no authority in the law of the state of New York that because something is leased as opposed to sold, the use, which would otherwise be illegitimate, becomes legitimate. The reason I bring that up is I think Mr. Rousseau's credibility is on the line here. Nowhere in the letter that you just read into the record does this wild assertion that I've highlighted that he told the planning board on January 14th appear. I think we have to question his motivations. Also, I think we have to question the credibility of the applicant. As you well realize, ladies and gentlemen of the board, the facts here revolve around exactly what your interpretation will be. That is, to whether there's warehousing involved here may or may not play a role, whether this is the type of use that's allowed in a commercial zone or industrial zone, I use the word commercial, I should say business in the town of Volney, is something that you're going to have to consider as well, and you're going to be gathering facts before making your interpretation. In listening to the facts and reading the record, I think the witness's credibility will be on the line here. And some of the things that Mr. Longley told the planning board on January 14th, 1992, including that he believed that he didn't have to pave this parking lot, that commercial parking must be paved with a dustless material such as gravel. He told them he's been dealing with the DEC and he has no problem with
Okay,
this.
that's not really relevant right now.
Well,
At this particular point. It may be relevant further on down the line if we decide that commercial parking isn't allowed use.
Madam Chairman,
Yes.
if you deem, based upon what Mr. Rousseau has told you, because of what Mr. Longley has told him, that this isn't warehousing, because these trucks are empty most of the time, then that's a finding of fact. If you're going to make a determination of a finding of fact, you have to determine the credibility of the person who told it to you. So I think we need to test the credibility of what Mr. Longley has told the planning board, who gave you the referral tonight to be able to make this decision. I'll move on, I understand your point, and I'll touch base on this later.
But at this point, I think all we need to do is interpret the zoning.
Right, and I quite agree with that. Now, also, exhibit number 3 is materials that Mr. Longley represented to the planning board. I've highlighted the factual context that he's given and that Mr. Rousseau has reiterated tonight. On the second page of that, the issue that's before us tonight, that is, our concern revolves around the belief that the commercial parking lot must be directly related to a business. The fourth document before you, item number D, is the public hearing notice for tonight's meeting, which does state precisely what is one of, I think, of the issues here tonight. And I want to caution you that I don't think the sole issue before you is to make a determination as to whether parked, loaded tractor trailers at a site for several days constitutes warehousing or not. I think that's one of the issues. I think another issue before you as interpreters of the zoning ordinance is whether this type of commercial lot falls under the category of that which would be an industrial use allowable in an industrial zone, or a commercial use allowable in a business zone. Even if the trucks are empty, assuming argument they have no beer in them, I think you still have to decide whether that's a legitimate use in a B zone. Now, there's the question before you. Is this use that Mr. Longley wants legitimate in a B zone? I think the answer is no. Well, how do we know that? Well, Mr. Longley has told us that. He told us in 1984 when he submitted Exhibit E, which is a zone change request, to the town board. Ask yourself, why in 1984, when Mr. Longley first wanted this use, did he ask for a zone change to an industrial use if he didn't already know that this type of use is only allowable in an industrial zone? How do we know?
Don't forget our 5-minute rule, man.
Yeah.
How do we know, Madam Chairman?
Mr. Cisco, I'll give you 2 more minutes and then I'm gonna ask you to stop.
Madam Chairman, I understand this is a very important issue to these people. I think you've got to understand that
There's
this...
a lot of people here tonight, though, that have come to
All you
speak.
see is 98 people that get on that list, and neighbors.
There's quite a few people. I understand the importance of, you've given us a packet here, I think
And
that
I-
we
and
should
I-
go through. We
Madam
don't
Chairman-
have to make a decision tonight. We have up to 60 days from the close of a public
I
hearing.
quite understand
to make a
that, but
decision.
you have to realize that 7 years worth of work has gone into this file. The political winds have changed. The people who were here in 1984 and 1985 aren't here anymore. I think it behooves you to be able to make an intelligent decision to allow me to just walk through these documents with you to suggest for example, that the environmental outfit hired by Mr. Longley in 1985, now pointing to exhibit number F, stated, if we can go to the last page of that exhibit, zoning requirements are such that this facility would be restricted from placement anywhere within the town of Volney boundaries except in an industrial zoned area. It goes directly to the issue of not whether these trucks are filled with beer or not, but whether truck parking in the town of Volney is allowed in a B zone. And Barnes-Williams Environmental Consultant said, no, it's not. Who's Barnes-Williams? Those are the people that Mr. Longley hired on his behalf in 1985. But they're not the only ones who said that this can only take place in an industrial zone. Judge Engelhardt, Exhibit G, finding number 10 on page number 3. In the case of Benway Stadium versus the town of Volney, and I quote, the town's zoning ordinance regulates tractor-trailer parking in an industrial zone. Again, it doesn't matter whether these trucks are filled with beer or empty. The issue before you is whether the parking of trucks is allowed in an industrial zone.
Okay, let me stop you for a minute. I don't know how the board feels about this, but what I'd like to do is go ahead and have the people that signed up to speak, give them their minutes to speak, and at the end of this, if the board agrees with me on this, we can have you continue, and for those of you that want to stay, you can stay. We'll give you your time.
Very
How do you
good.
feel about that? I think it's okay. Okay, again, the limit is 5 minutes. Barb McEwen?
It's 5 minutes, or everybody else is 5 minutes?
Everybody else is 5 minutes.
It should be equal to his.
I understand what you're saying.
Yeah, well, sure.
You can have my 5 minutes.
Okay, let's start from the top. Barb?
Okay,
Please limit your comments to what it is we're trying to do here tonight. You know, in terms of environmental impact statement, if this board decides that commercial parking isn't allowed use in and of itself, then Mr. Longley, if he still decides to apply, will have to go through site plan approval and special use permit, and seeker will be involved at that point. Let's leave it to that point.
okay, I know there's a lot of other ones speaking, so I'm just gonna bring up a couple issues that I've seen. Not only, we're talking about tractor trailers hauling beer right now, okay, and this is what, we know, because that's what you said you wanted to do.
You're gonna have to talk louder than that if I hear you.
I know I can't talk very much, but I'll.
We're talking about commercial parking and whether parking tractor trailers on his property constitutes commercial parking or warehousing. That's what we're talking
Well,
about.
that'll have to be determined by you. The only thing I'm saying is that, the tractor trailers that have been parked there in the past have had beer in them. As neighbors, we have a concern about the fact that there's theft through that beer. I've had a lot of, people knocking on my door asking me if I've seen anything in the neighborhood. And so, and when I looked up the definition of or parking, commercial parking, and it said cars and automobiles, it said nothing about tractor trailers.
Where did you find that definition?
With Vernon in the newspaper.
Subdivision 5, subparagraph B of the zoning ordinance.
So then it's not a definition we're talking
Would you
about.
like to see it?
Sure. Let's see it.
That's all it says is for automobiles and cars.
I think I got it. ZO15?
ZO15.
Four, 8, and 9 are the ones that refer to.
but in four it says, automobile parking space, automobile, nothing about trucks. And then in,
It says location of required spaces in any residential district, required automobile parking spaces shall be provided on buildable portions of the same lot. We're talking about a business district here, not a residential district. Okay?
right, but it says automobile, it says nothing about trucks. And then if you look on then to number 9, it's where it's, lots for more than 20 cars. It's all of this that, when you go to the front and it says commercial parking and it says where to refer, that you have to have a, special use permit, and you also, for the zoning board of appeals, you need a site plan approval, which you have to have 2 copies of the site plan approval in, the specs all have to be just right to scale. And then when it tells you here, commercial parking lots shall comply with provisions of paragraph B, subparagraph 4, 8, and 9. Then and number 4, what Jean just said, for automobile parking. And then 9, it says for 20 cars. And all of this, if you read through the whole thing, it says nothing about trucks, it just says automobiles and cars.
You want to add to that?
No, I think she explained it quite well.
Okay.
The only thing I want to leave you to say that the environmental circumstances have not really changed. What doesn't matter whether you lease it, whether you sell it, whether you rent it, what you do. The environmental problem's still there with the noise, the exhaust fumes, the gas leaking, the whole business.
Thanks, Bob. Kevin Connolly?
Here, I made copies of this so you can read right along. I gave one to Sylvan too, so she doesn't have to write everything down. Before you start the clock, I want to state that I live on Route 57, and I'd like to speak tonight as a citizen who lives on Route 57. As you know, I'm also chairman of the planning board. We'll deal with that in that position. I'm wearing another hat tonight. I'm also a concerned citizen who's lived on Route 57 for 7 years, and that's the terms under which I'd like to speak. This gets to and this does stick with the subject.
Okay.
As most residents are aware, there have been at least 5 occasions in the last 11 years when Banker Trucking or an affiliate have attempted to locate a trucking terminal on the residentially zoned stretch of Route 57 in Volney. Each time, the town board has taken steps, usually by zone change, to put an end to these attempts to locate an unwanted and unwelcome industry in a predominantly residential neighborhood. Unfortunately, as we all know, years pass, faces change, words and definitions are redefined, and sooner or later the resolve of the residents of this neighborhood are tested as a trucking firm again strives to locate in the area. Tonight's meeting is very important. I disagree a little bit with what you said earlier. The ZBA, through this appeal, can close the door on truck parking by removing the remaining loopholes left over after the town board zone change. By taking the correct action, the ZBA can truly perform its job in compliance with the overall zoning intentions of the authors of the master plan for the town and fulfill its obligation to preserve residents from these spot zoning abuses. There are 2 questions which the board has been asked to consider. 1, does this project represent commercial parking? I believe not, and I'll explain why and recommend an alternative. A lot of time can be spent twisting definitions. I propose we simplify it. A, it is clear through review of the zoning laws and the town's master plan that in 1972, the dramatic increase in truck traffic in this area was not anticipated. Tractor trailers are not mentioned anywhere that commercial parking is discussed. They are simply not referred to. If you refer to ZO15 on page ZO20, the only area where it mentions trucks is number 5, required off-street truck loading areas for manufacturing and permitted industrial uses. That is not part of commercial parking. That was specifically left out. Where you're discussing commercial parking, there is no mention of tractor trailers whatsoever. Okay? B, with this in mind, and by simply looking at the words commercial parking, it is clear in my mind that the master plan intended this to mean parking for commercial uses. meaning vehicles shopping at, involved in, or handling commercial businesses, such as banks, stores, or offices, those things permitted in our B1 zone. These tractor trailers would be dealing with industries, such as Miller's, Seal-Rite, or Nestle's. These industries must locate in an industrially zoned area. They can't locate in a B1 zone. They are not permitted in a B1 zone. Neither should the large vehicles which handle them and cause much of the problems which make these factories undesirable in a residential area. I want to stress, they're necessary, we need them, but when you're in a residential area, there's obvious problems. To me, to allow this would distort the intentions of the framers of the master plan and allow an unwanted and unsightly burden on the citizens of this town who voted for our zoning laws in the first place. Rather than make an assumption, I feel the ZBA should take this time to better define commercial parking, bring it more up to date, by limiting it to traffic whose primary purpose is to deliver to, shop at, or do business with commercial establishments in proximity to the parking area. You should then recommend to the town board the establishment of an industrial parking designation. This designation would be for tractor trailers and other vehicles that have business with industrial uses but are not provided with on-site parking. These lots would be permitted in an industrially zoned area. They may also be permitted in an agricultural zoned areas after receiving a special use permit. By taking this step, the ZBA would once and for all clearly define what is meant by commercial parking, make provisions for tractor trailer parking, while putting an end to this nagging controversy in a way that is fair to town residents. 2, the second question is warehousing as opposed to parking. This question was not raised by a resident, but by a judge whose job it is to review all the facts and from that make unbiased conclusions. He stated that trucks may be parked for several days, fully loaded, and that this may constitute warehousing, a use not permitted in a B1 or R1 zone. While I greatly respect our code enforcement officer, and I think he was done a little wrong tonight, he's doing a good job and he's doing the best he can. I do think his expertise is a little outside of the beer business and the trucking business. He says he only imbibes very rarely and very lightly. I think he was outside his expertise when he made statements regarding what the trailer's duration would be on the site and their loads. A, there is no guarantee that I know of that these trucks would only deal with millers. They could very possibly deal with other industries whose products are not time sensitive. B, from my experience in the business, beer has a lifespan of several weeks. C, trailers parked at other terminals just outside of the town limits frequently stay for several days, particularly towards the end of a week. Some have sat much longer, I've seen it myself. D, loaded trailers have sat for several days behind Longley's in the past. Pictures have been taken of the seals on the back of the trucks. E, and I'm just wondering, is there a representative of Banco Trucking or an affiliate here, someone in a true position to know, who can categorically state that the trucks would only be parked overnight? In the absence of a true representative in a position to make informed statements, how can this board feel confident that warehousing, excessive parking duration would not take place?
I'm not sure that that is not what we're here to decide tonight. If, in fact, we decide that commercial parking isn't allowed use, then it would happen further on down the line.
Well, it's two questions. One was warehousing.
Right.
I'm saying I think it does constitute warehousing. I'm just about done here. I think it does. I think I've seen off-the-road trailers parked in businesses and factories in the past, loaded, and they're used for warehousing. If you go to a construction site, the first thing they'll do is buy an off-the-road trailer and park it on the site and use it to store all their construction materials. In that case, it's a warehouse. That's a very, very common and cheap way of setting up portable warehousing. Finally, if you are basing your commercial parking designation primarily on the lack of a building on the parcel the service tractor trailers entering and leaving, look again. The building is there, a car and truck dealership does exist. Who's to say that tractor trailers won't be serviced by existing facilities? In essence, eventually, we would then have a terminal. As we all know, a terminal is not a permitted use. If your interpretation permits this parking lot, you are aware that the planning board cannot deny this use. We already appealed the determination. You are in the position to finally close the door on this matter or break it wide open. It would set a precedent that could cause this to happen again and again. Please act in the best interest of the residents of the town, the ones who will have to live with the consequences of your actions. I feel that I have spelled out some alternatives. I hope you will give them serious consideration. Thank you very much for your time.
Bill Box?
I'd like to just speak with regards to the intent issue that you brought up, Madam Chairman. I was involved back in '84, '85. Vern reminded me that I, in truth and in fact, presented the petitions on their behalf at the town board back in those days. I was in the audience the night the town board ruled on this issue back in 1985. At the point of ruling with regards to a convenience business zone, Supervisor Kimball said, "Does this mean no trucks?" The answer was yes, and that was the intent of the town board at that time. Thank you.
Thank you. Let's see, Newell Story?
I'd rather be someplace else. I wasn't gonna say it, but I had charge of the yard, Seal Right. We had real problems with trailers there. We had to store the trailers that we were using. Several times I've seen a transfer of cargo at that. That's warehousing, right? One time it was candy bars. You wouldn't believe the number of candy bars that are being squished. If you see trailers back to back, you can bet they've got something in them.
Well, maybe you can clear something up. You're saying that the transfer of
Cargo,
cargo
from one trailer to the other.
is
To move it
warehousing,
from
that's
one,
what you're...
yeah. Okay?
Mhm.
I think this would be worse than warehousing. Let's see, it was a real sunny day last week. I don't know what day that was, but the trailer came out ahead of me at Pierce Drive. He pulled right out in front of me, for that matter. That's the other thing. I think we got so many trailers pulling out on this, it doesn't know. But he pulled out in front of me, and I had to stop at the waterworks. I couldn't see anymore. I was right in a snowstorm. That trailer had to go by. If we had this, we'd have a worse condition than that, I believe. The trailer's stored in a snowstorm and pulling out. On Pierce Drive, there's been several break-ins to trailers. Have people heard about that? There's been some real good kids that have gone wrong. Not only them, but their families, their grandparents, and everybody else.
Okay, I think again, we need to limit the comment to definitions of warehousing.
This
and
is
commercial
breaking
parking.
into trailers that are storing things.
Okay.
Warehouse, right?
That's true.
Now I just, I'll have to stretch it out to make 5 minutes. I hope with all my heart that this wouldn't happen to anybody in this room. That somebody would be brought up just because this board allowed this to go on. Thank you.
Thank you. Harold Longwood.
I really don't have too much to say. When we first started, we sold the property, then it was turned down. Then two or three different times, we tried to rent it out, and this last time, and I guess it's up to you folks to determine whether we are able to carry on a place to have trucks to stop and stay overnight and move on. My brother isn't here, he's the one that ordinarily was taking care of us. But I don't really know. It looks like what your decision is what we're going to have to abide by.
Okay, is that it?
All I really have to say. I mean, we really got to wait until you decide what you're going to do.
Okay. Thank you, Mr. Longwood. Gary Richardson?
I don't have much to say either. I just, part that bothers me is we live in a community where we've got a lot of industry now. We've got Millers coming to the area, we got Owens, Illinois, and we've got a lot of industry in the area. If you drive up Route 57 from Fulton all the way out, 90% of it is commercial property. There's some residential people in there, I understand that, and that's my biggest complaint, I mean, if we're gonna have this industry in the area, we've gotta take care of these trucks, whether they put them there, or where they put them. I just don't see it being a big problem, no. I don't live there, so that's one advantage that I have that these other people don't have. I understand that. Well, all I'm saying is, if we're gonna say, okay, Owens, Illinois, come on into Volney. Okay, Millers, come on into Volney. We'll take care of you, we'll give you tax credits and all this stuff, and then, well, what are we gonna do with all your problems that you're bringing into the town? We gotta take care of the problems as well as the industry. That's all it is.
Vern?
I think the main reason why we're here is because of in 1985, September of 85, when Mr. Kimball, we had the meeting to rezone Longley, and they were changed to convenience business, which is B1. It was stated at that meeting that it was to be no trucks. There were different ones in here that asked Mr. Kimball, and that was the whole concept of the meeting, no trucks. But Alice Battle, when she did up the minutes, she did not put it in. And in a way that I blame myself that I didn't come the following month in order to read the minutes when they were to be approved as read, which there was a neglect that happened. Now, there's a lot of people in here that were at that meeting, and I think it would be an advantage to us if you would take account of how many people were here so that you know how many heard Mr. Kimball say no trucks. Can we do that? Sure. We have a show of hands of everybody that was here and heard that. So there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 14, 15, 16.
Now can I have a raise of hands of all the ones that weren't, that were here, that were in favor of it, that heard that? But I'm just saying, I mean, that's
Okay,
just
point
crazy.
of order. Go ahead, Vern.
Again, I'd like to say about the zoning, right on the zoning, when Barb was up here talking and it says commercial parking lots, it stipulates for cars and automobiles, no trucks. That's what the zoning says. So I don't know how you can deviate from the zoning. There's nothing at all in it that says anything about trucks. When Benway was parking trucks up there was a problem there. They were being broke into. And I did have a question that I asked when I sent you all a letter. I sent one to Bob Brown too, but I got it back. I didn't have your right address. The one question that I really wonder about is if the board passes the tractor trailer parking for Longley, and it does deteriorate the area, if it does pollute the wells, if it does depreciate the property, can the zoning board of appeals be held liable for neglecting to pay attention to the neighborhood? Because in the zoning it says that you have to, no, I don't have the part right now.
The health, safety, and welfare.
Yes, yes, and so if with everybody in the neighborhood that has signed it, everybody neighboring the Longleys has signed it and said that they were against it. So if they are ignored, would then the zoning board or the town board be liable because they ignored the people?
I'm not sure the answer to that question.
I think I can answer that. If we make a ruling, you don't have to abide by that ruling, you can go to another court, a higher court, and then it goes from there. Now, we're definitely, this judicial group make a ruling as to what the town board put in this book. If you don't like what we have done, or it doesn't sound right to you, you go to another court and let them decide.
You can certainly do that. You can also petition the town board for a change in the zoning.
That's right.
Okay, that's certainly or you can wait, you know, if we decide we're gonna approve that it's commercial parking, you can wait for the special use permit process. Although I wouldn't wait that long. That's certainly an alternative too.
Another thing, I think we've still got the wrong attitude. This is a judicial board, the board that interprets what the town board put in this book. Now, you can talk all you want, all we do is interpret the board to put this in.
We're just looking at the words.
And that's all we're here for tonight
Okay,
anyway.
and that's why everybody else is here, to let you know what the town board said that night.
But
And
the
that's-
proper people to go to is the town board, not this board. Go to the town board, tell them what they done, and have them change whatever
Well,
they
that's
want to
your-
change.
That would be
That's,
up to
no,
All
that's
we
an
do is
avenue that
interpret
you
what
can
they
take.
tell us.
If you don't like what we decide here, you can, as he's saying, you can take it to another court, you can take it to the town board, you can petition them for a change in the zoning ordinance.
Okay, but my feeling is that this shouldn't even come up, because it should have been in the minutes properly the first time. It was answered back in '85, and now we have to come again and bring this up and go through really the stress of it and the expense of doing this, and it shouldn't have to come up. It was already
I
settled.
can appreciate what you're saying. It stopped with the planning board. They felt that they needed more information. They needed a determination from us, and that's where things got stopped. And rather than just let it go, you know, they've come to us for an interpretation. Things should have been closed up a long time ago, but it didn't happen. Sally Day? Are we?
Dr. Day and Sally Day also signed a petition, and they couldn't come, they had to go to church tonight, so she sent this letter.
All right, I'll just read it. Zoning Board of Appeals, Town of Volney. We sincerely like the Longleys. We have purchased many cars from them and find their service to be exemplary and at a fair price. We, as many others, however, find the idea of a truck transfer station in our area repulsive. We already often have trouble getting out of our driveway, even at 6:30 a.m., and any additional traffic would further compound this, especially trucks slowing to turn and/or gearing up after leaving this proposed facility. We are very happy with the way Miller handles its environmental waste, but a truck stop with oil, fuel, and dust would serve as a ready source for soil contamination. As someone who's become a recent resident and is making a real effort to maintain attractive property, we strongly object. Sincerely, Sally and Paul Day. Bill Pierce.
I got to throw half my stuff out. I'd like to say, this is a case that makes the acceptance of zoning and land use regulations unacceptable to many residents of a community. You got different boards and town boards trying to convince people that zoning is good for everybody. But this issue here is being abused by a few. This issue was considered done and over, wanting to have service again. Under a different interpretation of right of use is allowed in the business zone. This issue being commercial tractor trailer parking lot is being an allowed use in this zone because the owner of the land is leasing the land to another tenant. An allowed use of land usually goes with the land and not who owns the land. With a determination that a commercial tractor trailer parking lot is allowed in the business zone, not only would it be a problem at this location, but it would open the use up to tractor trailer parking in any parking lot in a business zone. With only a couple of business zones in the town of Volney, we got more industrial zone in Volney than we have business. All around the airport, all around Miller's is all zone industrial where these things can be located. At the present time, it would mean that each area could have tractor trailer parking. With a possible shopping center going in the Pierce Drive area, changing that zoning from industrial to business, we could see more tractor trailer parking being allowed in the parking area of the shopping center. How often do you see a tractor trailer parking lot in a business district? This type of use just isn't allowed under the scope of our town zoning law. Now we got the shopping centers coming into town, being developed by the Light Waters groups, which is got a good reputation. They built one in Webster, New York, Webster Square. Last Saturday, in the back of the mall, it's going to be just like the one that's going to be located here. The lot is nice and clear. The loading dock, there's nothing at the loading dock. But you go down the side of the building, you start seeing tractor trailers parked. It's a business zone. And out in the front, it's kind of dark because I shot in the sun. Out in the front where the normal cars park, they park their tractors. And by the way Volney is growing, interpretation that this means that a commercial parking for tractor trailers is allowed in a business zone. This is the other boards are going to have to keep an eye out to prevent from happening. Thank you.
Charles and Eric?
Well, I think it's been pretty much said, but I wanna know about the air pollution, if this does come in, because they do stink.
Okay.
Anybody want,
I don't think we're at a point where we can discuss that right now.
well, about a year ago, they parking up the long lease, and they left, during the night, they've been running for 3 or 4 hours at whack, and that diesel fuel come right over into my house. I had to get up and shut the windows. Now, that's your turn to that.
Thank you.
And the noise.
And the noise, okay. Jeanette Neerman?
I live right next to Longley's. I live in the trailer. And like he just said, the past 2 summers, they had the tractor trailers going through here. Now, they come in through all times of the night, and when they're empty, they do nothing but rattle through the back of the trailer. Now, through the whole parking lot, excuse me. Well, they park and they line up back there, and you can't keep your bedroom windows open at night because it smells of diesel, and it is bad. And you can hear these tractor trailers out, the gentlemen that drive them, they do nothing but laugh, they tee-hee, they hot dog in and out of the parking lot going fast. I had called Mr. Russo on several occasions to have them stop, and he was told, Mr. Russo told me, that Longley's was servicing them at this time. Now, you don't service tractor trailers at 3 o'clock in the morning. There's no way. So I had called him on several occasions. I think this was for even the 2 summers, and they finally did get him out, and I thank him for that. But what are we supposed to do? You know, I have children. There's children in the neighborhood. What do we do? Do we smell diesel? Do we take a chance that one's going to come, not miss the parking lot, hit one of our houses? And which they do drive fast. There's no way that... And they don't just park way in the back. There was some right up next to the trailer. I could even describe what some of the tractor trailer drivers look like. They'd have their window up there at 3 o'clock in the morning, tee-heeing and all this. And I had called the state troopers a few times on this because of the noise, 3 o'clock in the morning. I have a small son. My husband works early in the morning. And they said there was nothing really they could do because they had to get a copy of the zoning record and all this. But in the meantime, the neighborhood suffers, and it was all the neighborhood, not just me right there. Thank you.
Thank you. I can't read who's next. Is it Charles? I don't know. Andrew? Thank you. Okay.
I'll wait till the end of the
Okay.
instruction.
Joe Stewart?
Yes, I agree with the letter. There is no personal vendetta in the lawn lease, and I believe it is an industrial use, and there is plenty of industrial property in the town, real close to Miller's, like it's already been stated. But I do disagree with Route 57 as being a commercial route. There are just a couple of commercial businesses on Route 57 in town now.
Where is it?
Thank you.
Okay, thank you. Diane Stewart.
Yes. I have a lot to say, but I'm going to give my 5 minutes to the young man in the back.
Which young man?
The young man with the mustache that didn't have enough time to speak because our lawyer was speaking. Okay? I think his name is Arduini. Okay.
Mine's already on there.
Okay, but you can have mine too.
Who are you?
Aaron Arduini.
Aaron Arduini. Okay, why don't we...
No comment.
All right. Okay, so then you don't want to make any...
No.
Earl? Who?
It's all been said for me too.
Okay, Aaron, you're up.
No comment.
No comment?
He had something to say before.
Yeah.
You want your 5 minutes back?
No, okay. Marie Austin.
Okay, so like old home week here tonight, you know, these old faces, we've been through this in 1984, and I was called tonight to come because I was on the board and I voted for this zone change. And I can tell you, I distinctly remember going through this many nights, and one of the things that was brought to our attention at the time was that Mr. Longley's property was zoned half industrial and half residential. And all he wanted was to rezone his entire property one zone. And that's basically what he was asking us to do. And what he asked us to do is rezone the entire piece industrial. However, there was a motive at that time, a talk of a truck terminal, basically what's happening here again tonight. And then the residents got together and they gave us petitions, and finally he did submit an application. And so the decision finally did come down, and there was a lot of discussion, and there was attorneys involved, that if we were to rezone his entire property one use, which was business convenience, he was able to operate his business. He could still have his junkyard, and the neighbors in the area could be rezoned, or could stay zoned residential, which would eliminate the use of tractor trailers going up and down Route 57, which obviously I don't think you have to be a rocket scientist to figure out that's going to be a big hazard if you have tractor trailers pulling in and out of that area. And Crescent Drive, I remember that was a big issue at the time because they wanted to pull down Crescent Drive and come off, and there wasn't enough, ingression or something, I don't know. There was all these technical terms that they couldn't get the tractor trailers in and out. But I'm very sorry to say that, that the minutes probably weren't correct at that time, because when we requested that the board receive copy of the minutes for each person, we were not given copies of the minutes. So if they were incorrect, I'm not surprised. Alice did the best she could do as far as keeping the minutes, and then she would read them at a meeting, and it was very difficult to pick up on every word and that it was put in the minutes properly. As a result, we do have copies of the minutes now that are given to the public, and that should have been done then. And because we didn't have proper documentation, this is why we're here tonight. But I can assure you that was voted on business convenience to allow him to operate his business and for the neighbors to have their residential area, and everybody compromised and everybody was happy, and we thought the issue was settled.
Thank you. Jeff Warner?
Yes, I was on the town board then, and I am still on the town board, and we thought the intent was there to eliminate the problem that is rising back up tonight. Other people have said there are land in the town of Volney that is industrial where truck parking can go. The intent of the town board then, and it was mentioned, that we felt that this problem was eliminated. So, we're back.
We just felt that at the time Mr. Longley compromised with the neighbors and the neighbor compromised with Mr. Longley, and everybody was happy, including Mr. Longley at the time.
You can't bring nobody.
Okay. Bill Goodwin?
My question or comment is either stated or answered.
Pardon me?
My questions or comments are either stated or answered.
Okay, thank you. David Collins? Did you want to speak?
No.
Your name is down. Let's see, is it Dan Hay?
Yeah, everything's really been addressed that I said.
Laurel Hay?
The same.
Mary Latino?
I thought I was signing the attendance.
Rita, is it Okanuski? Did I totally?
Well, pretty close.
Okay.
I drive a long lease car, and I like their service, but I don't like the idea of tractor trailers.
Is there anybody that did not put their name on this list that would like to comment? Okay, you have the floor, Mr. Cecil.
Thank you. I had last dealt with Judge Englehart's decision in the Fenway Stadium versus Town of Volney matter, in which he stated in point number 10 that this use can only occur in an industrial zone. There's been numerous...
Which one was that? H? Oh, yeah, where are you?
That was G, excuse me. That was G. There's been numerous references to H tonight. Mr. Connolly spoke of it. One board member spoke of it. This is the decision of Judge Balio, which overturned the planning board's permission to allow this particular use back in 1984. The entire decision has been reproduced for you to read in your deliberations. I would simply like to point out on page number 8 what Judge Balio said specifically to the issue that you're deciding tonight. The court notes that the proposed use could conceivably be a light industrial use in the nature of warehousing. In this respect, a representative of Banco Trucking noted that several trailers, as many as 50, fully loaded with beer, would be stored on the premises, perhaps for weeks or days, for days or weeks, excuse me. The agency having the responsibility for the interpretation of that ordinance might well conclude that storage of such vehicles amounts to warehousing. And it goes on to say that when ambiguities exist, that's not the planning board's function, that's the zoning board of appeals function. Ironically, what Judge Balio describes in his 1984 issue is precisely what I hear the residents describing is our status in 1992. Not only has Judge Engelhardt said that this is only allowed in an industrial zone, not only has Judge Balio said that this can be construed in the nature of warehousing, not only has Mr. Longley's own environmental consultants said that this could only take place in an industrial zone, not only did Mr. Longley himself say it has to be industrial, that's why I want a zone change, but I refer you to item number I. This is an excerpt from New York jurisprudence, the Bible of New York law, if you will. The first page, there's a discussion. What Mr. Rousseau is asking you to do in his letter, which opened tonight's proceedings, is to draw an inference that because there's specific separate mention of a commercial lot in your ordinance, that therefore the people who drafted it must have meant that it must be something other than accessory use. I submit to you that the law of the state of New York, Mr. Rousseau's intentions notwithstanding, I certainly didn't mean to insult him, and I ask your forgiveness if that's how that came across, but the law of the state of New York states an ordinance which permits a private garage but does not mention commercial vehicles will not be construed to permit the storage of commercial trucks. Isn't that precisely what we have here? Your ordinance, CO page 15, makes at least 3, if not 4 references to cars, and automobiles. Yet there is no reference to trucks. The law of the state of New York says, absent that specific reference, you're not allowed to make an inference on an inference, as Mr. Rousseau would have you do. You just don't have the authority. The law of the state of New York says is that the framers of this zoning ordinance wanted truck parking to be a separate, allowable use. In the town of Volney, in a business district, they would have had to specifically state so. And the absence of the reference to the language trucks, tractor trailers, or something of that sort, forbids you from construing this as an allowable use. Moving on to item number J. What I did tonight, or today, excuse me, in preparing for tonight, is I went through subdivision B to try to discern what the framers of this subdivision meant by the term commercial parking lot. May I point out to you some of the things that are referred to in that subsection B. Number 1, your law ties the size of the parking lot to the floor space of an adjoining or adjacent building or to the number of dwellings in the adjacent building. Does that sound to you like a truck terminal parking lot? Or does it sound to you like an accessory use? Your law requires in one instance that the lot, the so-called commercial lot, be within 400 feet of the structure that it services. Is this particular lot within 400 feet of the Miller Brewery? I think not. Doesn't this sound like a commercial parking lot that's adjacent to a structure that it services, as opposed to something that's a mile or so down the road. Your ordinance requires that the lot be paved. In fact, it says specifically that it be striped with painting. Now, you kind of told me not to talk when I pointed out earlier that Mr. Volney told the planning board that he didn't think he had to pave his parking lot. But the words of your ordinance are perfectly crystal clear. Parking areas shall be paved. The individual spaces shall be visibly marked with paint or other durable material. Have you ever tried to paint gravel? And you thought the credibility of the applicant wasn't an issue? I think it is. The Volney law that you're being asked to interpret tonight says that the lot will be lighted, with the lights being screened from nearby residences. Does that sound like the kind of lot where you park tractor trailers? I don't think so. The ordinance that you're being asked to interpret tonight requires that the lot be landscaped with lawn, trees, and shrubs. Does that sound like the people who drafted that ordinance had truck parking lot in their mind when they required it that it have lawns, trees, and shrubs covering at least 8% of the given area? And the ordinance is very specific. It says at least 8% of the area shall be devoted to landscaping. Sounds to me that that's the type of thing that you see in your typical commercial business zone. So that the landscaping made the parking lot more appealable to surrounding uses. And lastly, the ordinance requires that the commercial lot have a 6-foot wall or an evergreen hedge around it. Does that sound like the kind of thing you'd want to have around a tractor trailer parking lot? I mean, what's the point of a 6-foot wall if you got a 10-foot truck? Clearly, any fair reading of subdivision B, which you're being asked to interpret tonight, would lead every single person on this board, and you shouldn't take 60 days, you shouldn't take 60 seconds to decide this, that what's meant by commercial parking lot in this particular ordinance is a parking lot adjacent to commercial businesses. A parking lot adjacent to dwellings so that people can have off-street parking. Nowhere, as Mr. Connolly has so articulately told you tonight, did the framers of this ordinance contemplate a banking truck terminal, a Banco truck terminal. Item number K has gone on for now 8 years. First time it ever came up before any municipal board in the county was when, on May 23rd, 1984, the county planning board was asked to consider this same use, but here we are, 8 years later, considering again. And on page 2, what did they say? Staff recommends it's not a good idea because it causes a dangerous situation. Is your typical commercial parking lot next to the barber shop, or next to a library, or next to an apartment house a dangerous situation? I think not. Well, Mr. Longley doesn't take no for an answer. When the county planning board told him no in May of 1984, item number L, he went to the planning board, July 3rd, 1984, and they told him no too. You read the last page, Mr. Nagelschmidt made a motion which was seconded and carried, saying that because Crescent Road happens to have more than a 90-degree angle if approached by the south, it's just a dumb idea to put a truck terminal down the end of it. Well, I drove by Crescent Road tonight for the first time in 7 years, and it's just the way it was back in 1984 and 85. It hasn't been changed. Mr. Longley doesn't take no for an answer because after the planning board told him no on July 3rd, 1984, I draw your attention to Exhibit M. He comes back again, September 11th, 1984. And he says, I'll tell you what I'm going to do. I'll change Crescent Road. I'll make the turn so it's more easier for trucks to turn. And finally, after his third application, the planning board says, okay, we'll give you what you want. You change Crescent Road, and we'll allow you to have your truck terminal. And it was Exhibit M, that approval, which Judge Balio made short shrift of in that lengthy decision in 1984 that I read from earlier. So Judge Balio, when the planning board approved this one time, the only time it's ever been approved by anybody in Oswego County, reversed it within weeks. Mr. Longley doesn't take no for an answer, because after Judge Balio said no, he came back to the town board and said, I want a zone change. And Mrs. Austin was on the board at that time. There's another member of the board that was on the board at that time. And they got to the nuts and bolts of exactly the merits, or lack of merits, of this proposal. And they said, no, we're going to turn it down because it's got significant environmental effects, potential water damage, air quality damage. We've heard about that already tonight. Noise patterns, traffic patterns. We've heard about that tonight. It changes the neighborhood's quality and its use. Sounds to me, I haven't been up here in 7 years, but it sounds to me after the town board told them no in 1985, he went ahead and did it anyhow.
He did.
And I don't think you should be a party to that. And I ask your indulgence if I seem upset about this, but darn it, I am. How many times you gotta tell a guy no? Remember the very first thing I read to you earlier tonight, in which Mr. Longley, just 2 months ago, went to the planning board, Mr. Connolly's board, and said, I don't have any problem with the DES, or the Department of Environmental Conservation, DEC, they've got no problems with me. Wrong. Exhibit P. This is a letter from the local representative of the DEC, the Oswego County Health Services. They reviewed this same project that you're reviewing tonight back in 1985. And here's what they had to say. The site in question is located within the watershed of a Class D stream. They believed it was called Carrier Creek. A state pollutant discharge elimination system permit should be closely reviewed for possible impacts to the Fulton municipal wells located downstream. Should the town approve the zone change and be in a position to consider the special permit for the Longley truck terminal, parking lot runoff would appear to be a major concern from a water resources management perspective. Parking lot runoff. We're talking about a parking lot again tonight. 8 years later, hasn't changed. Back in 1984, the DEC identified this as a problem. But 2 months ago, Mr. Longley had the audacity to tell Mr. Donnelly's board, oh, I got no problem with DEC. No problem. That's exactly what the minutes say. And what about those minutes? Well, we've heard a couple of members of the town board say that Mrs. Battles didn't keep good minutes. I represent some municipal boards myself. It's a fact of life. Mrs. Battles is just like everyone else. She doesn't catch everything. Fortunately, the newspaper does. And you want to know what the intention of the good people of the town board was back in 1985? Well, I draw your attention to Exhibit Q. Supervisor Kimball, former Supervisor Kimball, was quoted by the newspaper. September 17th, 1985. My understanding is this doesn't mean trucking. That was a reference to the change from half R and half I to an entire B zone. That I understand, my understanding is it doesn't mean trucking. And Madam Chairman, as you said at the outset, you should look to what the members said back in 1985 when they changed the zone to a B zone as to whether they were contemplating a trucking terminal. Could it be any clearer than the quotation marks or quotations in the Valley News? Supervisor Kimball, my understanding is it doesn't mean trucking. Councilperson Austin, we have already concluded what we are here to do. Mr. Longley requested a zone change, and now we're done with it. I don't want to waste any more of our time or Mr. Longley's time. Or were we done with it? How many times are my clients going to have to hire me? Don't you think their money's better spent? This is the 5th time Mr. Longley's come to a municipal board in Volney and Oswego. When he doesn't get an answer from the planning board that he likes, he goes to the town board. When he doesn't like the town board's answer, he goes to the county planning board. And now he comes to you. Now, you've heard a lot of good things about Mr. Longley. He sells good cars, does it at a good price. People like him. People buy their cars from him. Well, I ain't from Volney, and I haven't got to say that, because I don't buy my cars from him. And I don't necessarily think he's such a good guy. Mr. Connolly said something tonight that you ought to take to the bank. It's time to put this issue to bed, once and for all. He didn't hear the first 4 times that a municipal board or a court of law told him no. And here we are doing it all over again. So I'm not going to kowtow to somebody I didn't buy a car from and say what a good guy he is. I'm here to tell you what the law of the state of New York is and how my clients really feel. How they really feel is that it's time for somebody to tell this guy no and put an exclamation point right next to it. Thank you. One last sheet I forgot to hand out.
Thank you.
Didn't have one, you wouldn't have a job. Like that? Huh? If we didn't have one, he wouldn't have a job.
Is there any additional comments? Yes, Kevin?
Yeah, I'd just like to say that, there was a couple comments that we just gotta take these words. Well, the problem is that just like statistics, different people mean words to say different things, you know? Somebody can say 10% unemployment is terrible, and then somebody else will turn around, well, it's better than it was last month, or something like that. You can get different interpretations. And it's the unfortunate aspect that these words aren't all that clear. That's why we need you to go beyond the words and make an interpretation as to what they mean based on, hopefully, what the original people who formed our master plan and put our zoning together and people who voted on it intended. And I think that we got to go, you know, although the word does clearly state commercial, we need to do that. And I hope we can do it in such a way as to, like the gentleman said, just get this thing behind us once and for all. Thank you very much.
Okay. Okay, so then it's really up to the board at this point, and the information that we've been provided with, to decide if commercial parking and warehousing go beyond the words. Is it not clear? Is it clear? And if we feel that it doesn't go beyond the written word, then, you know, there's a lot of other information that people have presented here tonight that we can take into consideration. How do you want to proceed?
Said I got 60 days to make up my mind.
From the close of the hearing, no? No, from close. No, it is in the- Oh, all right.
Madam Chairman, I think by looking at the evidence and reading the book myself, I think that the simple determination for us to make is whether or not parking trucks is allowed in the commercial zone. And I say, reading this book, I do not see it. I don't see how any other how anybody could convince me that it is included in that. And I think the solution is very simple, and that is to say that truck parking is not allowed in a commercial zone. And let anybody else determine what is allowed. I only know that parking trucks and reading this material, I feel it is not allowed. But if somebody else wants to say, you know, parking another vehicle, kind of vehicle, they can bring that for it. But is that not the question that we have to answer?
That's all we have to interpret, right?
Whether tractor trailers, yes. Does anybody else feel the same way as Jim?
I guess I agree with Jim. I can't see anything in here where it says anything about trucks being able to be parked. If you read it over and over again.
I guess I have a real problem with our use regulations where it says commercial parking lot in compliance with section VA7. And under B1 district, it says site plan approval and special use permit. And I'm just wondering, why is that there? Why is that there? If it's not supposed to be a separate use, I mean, commercial parking lot, it's listed as a separate use, commercial parking lot.
Is that a rhetorical question? Or should we get like some input?
No, it's a rhetorical question.
Think of a parking garage or a commercial parking lot where people are charged to park their cars. Those are uses that would fit within the meaning of subdivision 5A, or Roman numeral 5A and 5B, and not allow the parking of trucks. And I think that's, you've asked the $64,000 question. And that's what I've been thinking about the last couple of weeks myself. Well, what did they mean? And why did they put a separate use referring to commercial parking lots? And what type of use could they have had in their minds? And there's two that come to mind. A multi-level parking garage and a parking lot like we see, say, in downtown Syracuse, run by Marlboro Brothers, where you pay a couple of bucks and you park the car. That's why there's references to cars, not trucks. That's why there's references to a 6-foot fence. Cars are not 6 feet high. It all fits, but that's what they meant when they wrote this, back in who knows when, that they never contemplated a truck parking lot. And to consider commercial lots allowing a truck parking lot is a bastardization of the language that's clearly in the ordinance.
What does the Webster Dictionary determine commercial?
Commercial is as it relates to commerce, business, trade. That's what commercial means.
How do they interpret it?
Well, I don't know.
I got the
You have
dictionary. Yes,
This,
Brian?
this Town of Volney zoning ordinance, that it says updated 1990, all the pages in here says revised 1989. This book, when I sent those questions that I had, this was all the reference, because I thought this was the
And it's
book
not,
that you're
it's not
going
even
by.
been adopted.
Right. I mean, it annoys you that that all you people did all this hard work, and it hasn't even been approved yet. But in here, when everybody was revising the zoning, it does have a definition for commercial parking lot. It says an area where motor vehicles are parked for a fee. Now, that's an updated definition of commercial parking.
but totally illegal, has no standing, it has not even been submitted to the
Right.
voters.
Yeah, but that's what Jean was just saying, what did it
Now, she's
mean?
using the dictionary, but
I'm
So
looking
this
at,
was-
there's no definition
Yeah.
in our definition section.
But this was a definition that the board, that, I don't know which board came up, I guess it has to be approved
do,
by
I
the
was
town
there.
board. And that's what it says, for a fee. That's a definition that they came up with, and they got it from someplace.
I took a look at Anderson on zoning. Professor Anderson, Syracuse University, wrote the Horn book on zoning. And excellent question, because I wanted to look that one up myself, what was meant by parking and commercial parking. There's only 2 ordinances cited in Professor Anderson's Horn book, which define parking lots. And that's, I think, the city of Ithaca and the city of Syracuse both have a definition of it. And what both of those definitions speak to are parking lots, or things that have parking spaces of not less than, I think, 200 square feet or something like that. In other words, they speak of minimums, not maximums. And so I didn't really think that was relevant to tonight's proceeding, because if it specified a certain minimum or a certain maximum, you might be able to construe that only cars are intended. But by being defined by a minimum, it could be a motorcycle to a tandem tractor trailer. Both of those ordinances say a space not less than X. So I didn't really see it as being helpful.
Jean? This has been going on for so many years. We're all here tonight, and we request that you vote tonight.
That we vote tonight. Well, I'm not sure that I'm ready to vote. I'll make that perfectly clear. There's been a lot of information presented here tonight.
What percentage of industry is out here in Volney? Is there a high percentage of industry? I mean,
What is the percentage of industry in the town of Volney?
in town of Volney, you have a lot of industry, don't you? I mean, it's a big, mainly industry town. Is it or is it not?
It's not primarily industrial, I think it's primarily agricultural by nature,
Mean residential?
but primarily agricultural, I don't know if anybody.
No, I just wondered, because you said
Yeah.
something about industrial earlier, then it was commercial property. It
I
was
think
once
that
there, and I was just
Maria was
wondering-
referring to the fact that before Longley's was rezoned business convenience, it was maybe at best a split lot, industrial and residential, and they had asked to be rezoned industrial. And the town board said no, and you had it rezoned business convenience, is that correct? And the surrounding area?
Because it wasn't an industrial use, and in order to rezone an industrial use, you have to say why you want it to be industrial. And that's when he had to bring the plans about the tractor trailer to us, and that would have been spot zoning in the residential area. So we figured in order to compromise for him to run his business and for the people, the business convenient was the one that was given to us. And again, like I said, the attorney presented it, both sides of the fence, and we all agreed, and it was a wonderful compromise by everybody. And to answer his question, most of the town of Volney is zoned agricultural.
This board probably understands the intent of the zone change and the board. But we have to refer to the wording as to what it meant. And we have to go,
So did we, and that's what our job was too at that time too, and that's what we felt is what it meant. And they asked for our interpretation, that's how we voted unanimously that night. Mr. Ridgway was on the board, Mr. Kimball, myself. Who did another? Mr. Kimball, and that vote was unanimous, and it was discussed at length. That's what the interpretation was, and that's what we, as a town board, were elected to do, to give our interpretation and vote on it, and it can vote unanimously.
We understand that, but the interpretation of the way it's written might be something else. And
Well, you just said.
I want to study this a little bit more, and I would like to talk to some more. I don't want to hear one legal counsel, because we haven't got it. You know, that's the way they make their living.
Well, excuse me, Sam, but that's a contradiction to what you just said, because you said that you have to follow the intent of the town board, and that was our intent at the time.
I said I understand the intent of the town board, but that doesn't necessarily mean that the way they wrote it is the intent.
Why, I don't understand the difference.
Let a counsel tell me that.
Well, I just don't understand your logic.
Well, you don't, I understand.
The other thing, wait, I just want to also point out that in terms of warehousing, I've looked through this ordinance, and what I have found in the ordinance as it addresses warehousing would be on ZO 13, section VA, number 3, activity standards. In any district, the following standards for activity shall apply. Let's see, it's 3D. There shall be no storage of any material either indoors or outdoors in such a manner that it facilitates the breeding of vermin or endangers health in any way. A second part that I found it in, this is as it refers to warehousing. ZO 23, 3A, number 5. 3A says general standards. The following general standards are hereby adopted for the control of uses in any industrial district, and no use shall be permitted, established, maintained, or conducted therein which shall cause or be likely to cause. Number 5 says the storage or stocking of any waste materials whatsoever. And then on ZO 24, it talks about storage facilities. Materials, supplies, or semi-finished products shall be stored on the rear one-half of the property and shall be screened from any existing or proposed street. That is all that our ordinance really covers in terms of warehousing. And that's what we have to work with.
Madam Chairman, I see no alternative. If we should allow trailer parking in accordance to this ordinance, the fear I have is that paragraph B of paragraph 4, 8, and 9 do not specifically address the problems of tractor trailers. I think that we should state here emphatically that tractor trailers are not allowed, and we should refer it to the town board to specifically lay out the conditions for tractor trailers. That's my solution.
I think it also has to be, as Jim said, it's got to be stated specifically, tractor trailer. And not allowed.
I would like to make a motion to that effect. I make a motion to that effect.
Okay, would you restate it?
That tractor trailers is not allowed in commercial parking under business uses, and it be referred to the town board to specifically state the conditions for tractor trailer parking.
Well, wait a minute. We're still here for an interpretation. I don't know if we can do that. I don't know if we can refer that to the town board. We're just here to...
But I think the first thing that we need to do is decide whether it's an allowed use.
Right,
Park
and then
tractor
we
trailer.
refer to the town board. I don't think we can do that until we
Well, that's what-
make the decision.
I guess you know, numbers 8 and 9 are very clear to me. Numbers 8 and 9 are very clear to me. And the fact that it's listed under our use regulations also is clear to me. But I'm having a little bit of trouble with number 4. where it says in business districts or industrial districts, such spaces shall be provided on the same lot or not more than 400 feet therefrom. I'm not exactly sure what that means. Well, I think you made the comment that the not more than 400 feet therefrom meant Miller Brewery. So
Yeah,
now
we
what
did
you're
refer
saying-
to
It seems to say it's gotta be on the, because the two sentences read together, the first one says it's gotta be on the lot, if it's residential, and then if it's commercial, it's gotta be within 400 feet of thereof. And I thought that meant the commercial lot, or the commercial use, or the commercial structure. The clear intent, my reading of it, was that the parking lot has to be close to the structure that it services. And we don't have that here. And what type of situation do we usually have that? The parking lot in front of the barber shop, the parking lot in front of the library, the parking lot near the apartment house, the parking lot by the mall, the parking lot by the plaza, all of which are car parking lots, and none of which are truck parking lots. The only way that you can square all of the language in 4, 8, and 9, and I think if you're going to try to determine the intent, I think you have to look at everything, not just 4, 8, and 9, you gotta read the whole section. The only way you can square all the language in the section is that what they meant was some type of commercial parking lot where people are charged to park their cars, so they can go to nearby stores, or park overnight for a nearby apartment. We see that in larger cities as well. There's nothing in there that would lead me to believe that whoever drafted that ordinance was thinking about a truck terminal parking lot. And as Mr. Connolly has said, it's almost ludicrous to think that the people who developed the ordinance prior to the industrial boom in Volney in the early 1970s could have ever envisioned the need for a commercial truck parking lot. It's something that they could not have ever conceived back when they drafted the ordinance. But what could they have conceived? The type of thing that's across the street from the War Memorial in downtown Syracuse, where you pay $1.25 and you park your car, and you go to something that's within 400 feet of where you just parked your car. So it would be a long stretch for your board to say that they must have been thinking about trucks when they drafted this ordinance. And if they did think about trucks, why are there 3 references to cars, 1 reference to automobiles, and no references to trucks? As Jim has stated, there's only one fair way to read that.
Yes, I just want to I agree exactly what he just said. That's the whole point. At this time, when this zoning was drafted, there was no big industry, no big Miller Brewery, or all these industries we have now. And when they come in, they build the parking lot adjacent to the factories, providing that would be ample parking for the tractor trailers. You're right. He's exactly right. There was probably no determination at that time that down the road, a half a mile, they're going to need adjacent parking for these commercial trucks. So it is not addressed. So therefore, how can you make a determination when you don't even have the word tractor trailer mentioned in any of the zoning? Because it wasn't the intent of the, like you say, you have to base it on the interpretation of the people that wrote it. Or they weren't even considering that. So I don't know how you could base your decision on that.
And if I could just add to that, the reason I gave you this portion of the New York jurisprudence is to point out that the law of the state of New York seems to say, absent specific language in the ordinance that you can hang your hat on and say, yeah, they must have been thinking about truck parking here, you can't do it. You're not allowed to draw an inference on language that's not there. Because the ordinance is silent, you're not allowed to say, well, maybe they did mean trucks. You're not permitted to do that. And the only conclusion that you can draw from an ordinance that makes 3 references to the word cars and 1 reference to the word automobiles and 0 reference to the word trucks, that they didn't want trucks in this neighborhood and B zone. It's the only possible and logical conclusion.
Yeah, I think Jim's right, when it's all done, then recommend the formation of an industrial parking designation. Because it's gonna happen again, obviously, otherwise, so. I'm recommending setting up an industrial park for trucks and vehicles which handle industrial use.
Any other discussion? What, can you please restate the motion?
The tractor trailers will not be allowed in commercial parking under business uses. And we recommend that the town board to specifically state where tractor trailer parking is allowed.
Read that again.
Tractor trailers not allowed in commercial parking under business uses, and we refer to the town board to specifically state where tractor trailer parking is allowed.
That's kind of throwing the buck in it. We're supposed to determine what that reads tonight.
Well, that's what I am saying, it isn't in here. They can decide about where it does go.
Then you put this board is
Not
for.
our job.
He's saying where trailer truck parking.
He's
In the
saying that
future.
it's not, no, what he's saying is, one, that he feels that given information and the reading, his reading of the ordinance, that, tractor trailer truck parking is not an allowable use in a business convenience zone.
And if it's going to be allowed, that's up to the determination of the town board, not us.
Just as we did the other night when we made an interpretation on the Trail of Terror, we made an interpretation as to whether it was an allowable use, and we said, yes, it was, but we recommend to the town board that they, and we can do that.
May I offer a suggestion? How about two resolutions or two motions? One, determine whether trailer truck parking and tractor trailer parking is or isn't allowed, depending upon whoever makes the motion, in a B zone in the town of Volney, under the language of Roman numeral 5. And then after you, assuming that that goes in the residents' favor, then a separate motion recommending that the town board, through amendment or otherwise, determine where in the town of Volney you are going to park these things. Since you now determine through your interpretive powers that you can't park them in a B zone.
Dave, were you going to say something?
Yes, Chief. I think that there was a question that you were to answer tonight. Can you state that question? There was the
The
answer.
question was, what was the question? Somebody
Yes.
tell me what the question was. Well, what we're going to do is determine, or make an interpretation of the ordinance as it relates to commercial parking, basically. And secondly, whether parking tractor trailer trucks, fully loaded constitutes warehousing. Those were the two things I think that we used.
Okay, can you vote on those? If those are the questions, can you vote on them? Because I feel you're, cannot turn this back over to this is your responsibility. You have to answer those questions. Once you answer them, then you can come up with other questions and other
Well, I think we have to
responsibilities.
vote on the questions that we brought up, and then
Yes.
from there, if we feel that we want to make a recommendation, we can do that.
Please.
Right. Okay, all right.
That's exactly what I said.
Jeannie, in order to make sure the minutes are done properly, I think two separate motions are really, that's a very good idea.
Okay, all right, let's go back to, where did I?
Restate your motion.
That's how they left.
No second. All right, what was the first, what did? Where's my
Oh,
screen?
warehousing over, I think we settled on parking, but I don't know about the warehousing.
Okay, the second part was whether parking loaded tractor trailers at a site for several days constitutes warehousing. We have very little to follow. I guess my own personal feeling is the language is not is not clear. It doesn't refer to, tractor trailers. And I read from 3 or 4 different areas in the ordinance where warehousing was addressed in its very limited way.
And I respectfully point out to you that the question that you're now considering, which happened to have been the one that was published, wasn't the one that the planning board threw to you. The one that the planning board threw to you in Exhibit C of my submission said our concern revolves around the belief that a commercial parking must be directly related or have
to the
right
to the building or whatever.
I think the determination of warehouse, whether something is or isn't warehousing, requires a factual foundation, which you may or may not have enough information to make a determination on. Anyway,
Really?
but you can still resolve the question that the planning board has given to you, which is simply, is tractor trailer parking allowed in a commercial lot in a B zone? And that's the question they threw to you. It kind of got
Well, it kind of got muddled a little bit.
It kind of got
with
muddled
the
because
warehousing.
somebody obviously read Judge Balio's
Yeah.
decision when he asked, well, that question. But really, the one that Mr. Connolly's board gave to you is simply,
Whether
is
commercial
tractor
parking.
trailer parking lots allowed in the B zone?
And that was my motion.
Okay. All right, so,
Do we ever have a second?
Read the motion.
We have a motion that tractor trailer parking is not allowed in the commercial parking under business uses, and that we recommend to the town board to specifically state where tractor parking.
No, we don't want
Cross
that in.
part out.
Yeah.
Tractor trailer parking is not allowed in commercial parking under business use.
I'll second that.
I was gonna say before you second it, maybe we should just make it a little bit more clear in terms of the part of the ordinance that we addressed. You said under general business, what did you say?
Under commercial parking, or in commercial parking under business use.
Under business uses, and, what were the specific sections? VA 7, subparagraph 4, 8, and 9.
I still got some wood, but I see it, but you haven't used it. Well, you haven't used it. Everything is preserved if you don't use it.
Chairman Conway,
Yeah.
Sam Kukurudo,
Yeah.
Jim Hinman,
Yes.
Deborah Sprague. Yes. Dave Winfield.
Yes.
Okay, that's motion number 1.
Motion number 2.
Do you want to still do that, recommend?
Yes. I would like to make a motion to recommend that the town board address
Tractor trailer.
tractor trailer parking.
Dave Winfield seconded the first motion.
I'll second that.
Let me say it louder.
Yes.
Okay, I recommend that the town board address tractor trailer parking in the town of Volney. Okay, it's that simple.
Chairman Conway?
Yeah.
Is there any discussion?
Oh, we can have some discussion, sure. If there is discussion, go ahead.
Could you tell me how the town board is supposed to address this question?
If and where there is going to be tractor truck.
You've got to make the laws for us, right?
Right.
You have to have a public hearing.
We would have to have a public hearing, determining who and where it can be done.
I think basically, where this would,
Get a tent and put it up on the property.
Go ahead, Dan.
I think where this would come in would be like under a zoning, a revision. to your
Amendment of the zoning ordinance.
An amendment.
Amendment.
And then the town board approves the final amendment that is made to the
We're
zoning.
recommending, right?
Yeah.
We're making a
The recommendation.
recommendation, there's nothing that has to be done, we're just recommending. That this be specifically addressed, because it's been a problem for years and years and years.
And what we're saying with the first motion is that, tractor-trailer parking is not allowed in a business convenience zone. So where is it allowed?
Right.
And this will stop anybody from coming back and filing to you again until the town board
Right.
makes a final determination.
Okay?
We can tell you anything, and you could say, go take a walk.
But I think Jim's right, it's gonna come back again.
It's gotta be addressed.
We've got Miller, we've got,
Armstrong, we've got,
we've got other.
There's lots of things.
You got the airport,
Right.
I don't know. Yes. Got two dumps.
Chairman
There's all
Conway,
agriculture.
Yes.
Dave Kukurudo,
Yeah.
Jim Hinman,
Yes?
Deborah Sprague, yes, Dave Winfield.
Yes.
Yes, we're done.
I make a motion, yeah, we're done, I make a motion, we adjourn the meeting.